Hello, we're less than a week from early voting and less than 3 weeks from the March 3rd Republican primary for District Attorney of the 97th Judicial District. There's been a lot said in this campaign. I want to point to one that there's no supporting facts for whatsoever that's been made by my opponent. And actually, I'll tell you, she knows better by personal knowledge. She and her campaign manager wrote in a mail-out, Casey Pohima's opponent would need to catch up on 40 years of changes in criminal law, the Code of Criminal Procedure, and the Texas Penal Code. We cannot afford a DA who has to play catch-up. Neither she nor her campaign manager have any idea what cases I've handled in the last 40 years in criminal law. There's just no way for them to know that, and I did. In the last 10 years since I moved back to this area, they'll have no idea what felonies I handled in other places or misdemeanor criminal acts in county courts. One in Travis County is recently last fall, a criminal contempt case I tried against the Attorney General's office with a very good result. But there's 3 in particular out of the 4 that I handled right in the 97th that my opponent has personal knowledge of. She was the assistant district attorney when 3 highly publicized cases were taken over and defended by myself. The first was a first-degree felony, life in prison faced, embezzlement charge, theft. That case was a priority, I was told, by the previous district attorney because of the influence in the community and the fact that it was alleged white-collar crime. I filed a motion after reviewing the 10,000 pages of documents in the accountant's report to have the indictment dismissed for failure to state a proper cause of action under the criminal code. On the day of the hearing, the district attorney elected to dismiss that and re-indict my client. I filed a motion to dismiss the second indictment for the same reasons and carried forward and refiled my motion to exclude the accountant's report under the Texas Rules of Evidence because it didn't meet the proper standards of a formal audit. Unfortunately, the client passed away while that was pending, but I have significant reason to believe that those motions would have been successful. About a year later, I defended State versus Underwood. That was a reckless homicide facing 20 years in jail. That case made every newspaper from Wichita to Dallas and the webpage of the New York Post and the LA Times. By understanding the criminal law and reviewing that file and the official statements, it was reduced to what it should have been, and that is a negligent death. That carried 2 years for which he was given probation instead of 20 years. It was a foolish act by 2 18-year-olds that unfortunately resulted in a death, but certainly had no substance to support the original stronger charge. The third case was against a former law enforcement officer, and that case carried forward to when my opponent was actually elected and sworn into office, and she recused herself from defending or bringing that case against me and the one I was defending for my client. I filed a motion to dismiss in that case based on the Code of Criminal Procedure and the Penal Code, and after the special prosecutor who was appointed, a long time experienced and very learned counsel, he elected to dismiss it and gave notice to the court and to the district attorney that I was correct. It's my understanding of the Code of Criminal Procedure and the criminal statutes of this state that led to the appropriate results in those cases. I've had other successes in other cases in other places. I'm certainly not playing 40 years of catch-up. When you go to the polls, when you evaluate who you want to vote for, please take a long look at the things that have been said here, especially in light of this particularly unsupportable allegation. I would like to have your vote. Thank you for listening, and God bless you.